evening. Welcome to our Saturday international get-together between Ontario and Texas. Kimi-Lyn and I are here with Claudia. Welcome back to the Andy Martens Show and Real Talk and Empower, Speak Up and Empower Hour as well. We're across around the world on 60 Facebook pages, and Kimi has got another great guest, a candidate for governor in Tennessee, John Gentry. Welcome to the show. He joins us from his home just outside of Nashville, Tennessee. Good evening. Welcome to the show. I just want to ask you around the political end of it before I give it to Kimi. John, you're running for governor. I find that politicians are not being as open as possible to us, or I've seen it in Canada and the United States. Kimi and I are still trying to interview Texas Governor Greg Abbott. Politicians need to answer the tough questions. I've tried to get many interviews with Premier Doug Ford in Ontario, and if he doesn't like the way you think about the pandemic, or he kicks you out of cabinet, kicks you out of caucus. I mean, this is not the way. I'm going to bring this up in the federal election in Canada this year and provincial election next year. I wanted to get your feedback in the great state of Tennessee. Perhaps Marsha Blackburn, the senator from Tennessee, is probably, I'm thinking she looks pretty hospitable and willing to do interviews. But are you seeing that kind of thing? And politicians only talk to people they want to talk to because they get the answers they want to hear?
Well, I'm not a politician. I'm a patriot, and I'm a warrior, and I'm fighting for the people. But what I see of politicians and those in office is absolutely, if they don't like what you're going to talk about, they just won't talk to you. And very often they talk out of both sides of their mouth. I mean, Governor Lee here in Tennessee, he's talking about, our kids aren't wearing masks in school and we're doing away with these COVID restrictions. But he was out there propagating COVID restrictions as much as any of these liberal governors that were out there. And he knows. He was at a site in the school where kids are wearing masks in school. So he knows. So they're talking out both sides. They have no incentive to be honest and to actually work for the people, because there's absolutely no accountability in government today. And that's what my work is about restoring accountability, about restoring justice.
Absolutely.
Right, exactly. All right, Kimi, it's your turn.
Excellent. Well, Andy Martin, thank you very, very much again for our seventh show together. I'm super excited to, as Andy Martin mentioned, introduce the Tennessee gubernatorial candidate, John Gentry. Claudia and myself, as a lot of our audience already knows, Claudia Ovias. Claudia and I work together for Texas Team 2503, and our journey together has been eye-opening in the least. And where we have sought out Mr. Gentry is that what we have found all the way up the chain, all the way up the food chain in the legal system, is perpetual corruption all the way up. And zero accountability all the way up to our legislature. And when we came across Mr. Gentry's video with respect to restoring accountability from the ground up, it was music to our ears. And so I am delighted to have Mr. Gentry on our show tonight. And I hope that we can rally. Claudia and I work with several groups. We work with fathers' rights groups. We work with parent right groups. We work with multiple groups that are all in the interest of welfare of children, child welfare. And it's interesting how, even though we found ourselves in there due to the family court, it really has nothing to do with family court, because all of the children are all being treated the same. All of the parents of the children are being treated the same, regardless of whether or not they're in the system. And yesterday, unfortunately, we got yet another taste of that. So to Mr. Gentry, welcome. Can you please tell me what inspired you to wage you to what inspired your knowledge of the corruption? What brought it to your attention?
Well, I served 8 years as a Force Recon Marine, and I lost friends in service, and I still am losing friends, caused by service today. And I refuse to accept for my service, the service of my colleagues, and for all of the men and women that have sought to establish and preserve this republic, that they did so in vain. So that's why I'm in this struggle. What brought me to it first was I was involved in mildly corrupt legal proceedings, and it was mostly about property. As I sought justice through that, I went to everybody: media, law enforcement, FBI, TBI. Nobody would do anything. I went to judicial oversight agencies. I took 2 cases through to the Supreme Court of the United States, as well as through the state courts. And there is absolutely no remedy when it comes to corruption, especially in the judiciary and with legal professionals. Judges are literally above the law. They can violate rights, perpetrate crimes under color of law. Once I saw that, I started researching and learning, getting out there and seeing all these groups that are out there, like you're talking about, fathers' rights. And the most atrocious one to me is the criminal activity that goes through Child Protective Services, where they literally steal children under color of law. I've written articles about it. The foster care system is the #1 source of child trafficking in this country, not for the actual trafficking of stealing them from parents, but they're what feeds prostitution. It actually comes from the foster care system.
Agreed. So I want to just stop you there, because everything that you just lined up to. So like yourself, we came in under something mild. You would think a divorce. And exactly as you aligned, every step of the way was another roadblock to holding the person or the entity just below accountable. So in our instance, we had an issue with lack of enforcement. That's okay. We'll go to internal affairs. Internal affairs is being told, no, go to the DA. The DA is saying we get the option to choose what we hold people accountable for. Then I called the FBI. The FBI appeared to take the lack of protection of my child seriously. And they said, well, I want you to call the FBI, and I want you to call internal affairs, and I want you to call your state rep. None of them care. None of them care.
This has to be common sense. We are all aware of rampant corruption that is going on in courtrooms across this country. It is common sense that if any kind of oversight mechanism were working, law enforcement, media, government agencies, if any aspect of that was working, we would not have judicial corruption. So the fact that we have judicial corruption means that literally everything is broken, and literally they're above the law. But we are having some success here in Tennessee. I took 2 cases to the Supreme Court of the United States, and the Supreme Court won't hear it. And I filed a motion to disqualify all 9 justices of the Supreme Court of the United States. I said, this couldn't be happening if you guys were doing your job. And so you must be biased. The Supreme Court justices must be biased, because they won't hear cases about judicial corruption. And the Supreme Court of the United States did not answer. They did not grant or deny my motion to disqualify. They ignored it, in my opinion, in violation of USC. So you go that far. You go to the highest court and you don't get justice. And most people would just walk away and say, wow, I just spent tens of thousands of dollars. I just spent 2 years of incredible effort, and it was all for nothing. I didn't get anywhere with it. I'm a Force Recon Marine. One thing we're known for is we don't quit. Under any circumstance, we never, ever quit. No matter how arduous, how difficult, how miserable, we don't quit, period, ever. So I'm not going to give up. So I started researching this and working with friends that are like, we're not getting any relief in the judiciary. We need to go to the legislative houses. And so that's when I started like, well, how do we do that? And I started looking at the legislative houses have rules of order. And in Tennessee, they have, it's like rules of procedure for court. Legislative houses have rules of order. And Rule 15 in the House and 22 in the Senate says that petitions shall be received and read at the table after a brief statement is filed with the clerk. And as I'm reading through this, my Tennessee Constitution says that we have a right to apply to the powers of government for redress of grievance or other proper purpose by address or remonstrance. So I started researching that and started digging into the history of that, going down to the Tennessee archives, looking at the House journals, looking at what was the process back in the 1800s when they did receive petitions. And what I learned from this process, this right is in the First Amendment of the United States Constitution, that we have a right to petition for redress of grievance. That knowledge is so oppressed, it is stricken. It is literally stricken from the knowledge and memory of every citizen in this country, that nobody knows what that right is or how to recognize or how to exercise that right. And as I learned more about this right, it is the cornerstone of our constitutional system. It is the foundation of our republic. It is how we, the people, express our sovereignty and exercise our sovereignty over ourselves. I was reading, as part of my research, I found a law review article a friend of mine referred me to. And in that law review article was a citation to this book. It's a Bill of Rights documentary history, 2 volumes. And so I went out and I found these and purchased a set of them because I want to read for myself. And when they were debating about whether to include the right to instruct, whether in the Tennessee Constitution we have a right to instruct our representatives. Tennessee is one of 3 states that have a right to petition by address, orally address our legislative house, and also we have a right to instruct. And so I did not realize what that right to instruct means. It means what it says. It means we literally have a right to instruct our representatives. So in the first Congress, on August 15, 1789, and this book has the committee hearing. It has basically a transcript of what they talked about on August 15, 1789. And what they said is in there is that sovereignty rests in the people. And for them to say that sovereignty resides in the people and that we don't have a right to instruct is ridiculous. It's absurd to the last degree.
Yes.
Because, our Constitution, our federal Constitution, we the people, in order to form a more perfect union, we created our government through our Constitution.
Yes.
And the sovereignty, resides with us. And they stated it in that 1789 hearing.
Yes.
They said, sovereignty does not reside with the legislature; it resides with the people, and we have a right. We have a right to instruct them. Now, Texas, you don't have a right to instruct, but you do have a right to address them. So that means you can get a group of citizens together in Texas and go to them. This fixes everything. I mean, when you look at, we have a right to instruct our representatives. He said, if there were ever an occasion where all of the constituents agreed on something and instructed us to do it, that is the sovereign will of the people.
Yes.
If everybody wants it, it's the sovereign will. So we all want term limits in this country.
Everybody.
98% of us want term limits. It is the sovereign will of the people. So if everybody in this country got together and 98% of the voting public signed a memorial and remonstrance and filed that with the United States Congress, we would be expressing our sovereign will. And they would have a duty to amend the Constitution and put in term limits for congressmen, just like they did for the president in the 25th Amendment. they would have a duty to, and with that right, with that right to instruct, that we have here in Tennessee, it means they have a duty to hear our petition, to hear our grievance. They have a duty to consider it, and they have a duty to decide it. And that's exactly what they talked about in 1789 was what does that mean, that right to instruct our representatives?
Yes.
So this is
we have a lot to unpack there. We have a lot to unpack. So I'm going to take just that little brief section because we're gonna let you continue to give us all of this information. But I want to take just a little bit. First of all, I would like to commend you. So just as a citizen of the United States and looking at the state of our union, what I see as a 50-year-old woman born and raised in the United States is that there is a lack of willingness in our country to be as assertive and direct and brave as you are being. I don't know what has happened to our society as a whole, but I want you to know that I look at you as a wonderful role model for the people that should be in our government who are unwilling to cower on how they feel and cower on what is right for the country as a whole. Thank you very much for your military service. And I don't know if it was your military service, your upbringing, but whatever it is that gave you the lion heart that you have now, I am extraordinarily grateful to be a patriot alongside you. So I want to put emphasis on that because as a whole, I feel like the U.S. is not as strong as we used to be because of that one characteristic that you so strongly have. So I want to put emphasis on that. So thank you for that. So secondarily, you mentioned that yes.
So, you talk about it's the weakness in the people that they do not perform their civic duty. They do not oversee their government. They consider their sole civic duty getting out there and voting. But to address your comment though that people are lazy or uninvolved, I call it's a coma of apathy, distraction, and ignorance. So apathy, they just don't care. They're distracted. Sports, movies, everything else. A little less distraction now with the pandemic. People are starting to wake up by large numbers, and the ignorance. People are thirsting for knowledge now. So we're at a time in the history of this republic where the pendulum of justice has swung too far toward injustice. It is just now starting to turn. And when you have strong men that stand up, and I say men, I'm talking about mankind, not gender. But when a strong person stands up, other strong people will come to stand beside them. And as that happens, multitudes hardly thought to exist will also come to stand with us. A large part of this is that they feel helpless, that there's nothing that we can do. But when they see people like us getting in there and remonstrating, my remonstrance, the entire Tennessee Board of Judicial Conduct, all the judge members were removed from office, every single one of them. They vacated that agency. They reconstituted it, not with just judges. Now it has 8 judges, 2 attorneys, and 6 citizens. It's still unconstitutional. They're still not going to do their job. But it is incredible that one person caused all of those judges to be removed from office.
Good for you. Good for you.
So this is, and the reason I bring this up is not to pat myself on the back, but to show people that there is hope, that citizens can begin to oversee and take back control of our government. And when we start shoving the Constitution down their throat, which is what I do every single day, is I say, here's what it says, It says I have a right to instruct. It says I have a right to do it by address. And by God, you're going to adhere to the Constitution that you swore to uphold. And if you don't do it, I'm going to put it out to every citizen in this state. And I'm going to expose you, and they're going to see it. And I'm going to have it recorded in the record of every court that I can go to, federal and state. You're going to adhere to the Constitution. And the more that I do that, the more people that come and stand by my side. So this is how we get it done.
Excellent. I like just hearing you, like that is exactly what, I gotta reflect a moment. So we were working really, really hard on trying to get a 50-50 bill passed, 50-50 shared parenting. And clearly, as you know, that removes a lot of power from the judges who would rather meddle in a divorce. And we had 3 family court individuals who participated in that vote. And our Constitution said that they were not allowed to, and they did anyway. But the interesting part is, as you mentioned in another one of your videos, was there was no recourse for them violating the rules at the highest level of our legislature. So how is it that 3 family court lawyers participated in a motion to have 50-50 when all 3 of them directly benefited from the outcome of that? And so no recourse.
Go ahead, John. I have a lot of respect for what with Mark Ludwig and some of the main proponents of 50-50 shared parenting. Great respect. They're hard workers, good, well-intentioned people. But if they're not providing due process, and they're not, it doesn't matter what statutes you put in there, because they ignore the statutes anyway. So 50-50 shared parenting, in the end, if they're going to be corrupt, they're going to find a way to be corrupt and to not provide or adhere to 50-50 shared parenting. Here's the problem. You cannot have justice without a fair court, and you cannot have a fair court without judicial accountability. And there is no judicial accountability. There is no check of one branch over the other, because our corrupt judiciary has usurped legislative power of judicial oversight. Our state and federal constitutions provide that the House has the sole power of impeachment. And in my Tennessee Constitution, judges, they be removed by concurrent vote of both houses. So clearly, judicial oversight is a legislative check and balance of power. Judicial accountability is provided by our legislative houses. But our judiciary has usurped that legislative power by putting attorney officers of the court in legislative positions, and then voting to statutorily put judges in expressly prohibited second offices of trust in judicial oversight agencies, and you got the fox watching the hen house.
Yeah.
So you're never going to have justice without fair courts, and you're never going to have fair courts without judicial accountability. So these judicial oversight agencies have to be abolished, and we have to restore legislative oversight to the legislative houses. You also cannot have justice if you don't have a voice. If you can't raise your hand and say, I have suffered injustice, and if you can't do that, you can't get justice. And that raising your hand is the right to petition for redress of grievance. And that right is so oppressed that it is stricken from the knowledge of all citizens. It's stricken from our memory that we don't know what it is.
Yeah.
So this is my work now, is to educate the people that this is the cornerstone right of our republic. All rights flow from the right of petition. You know, government did not just say everybody gets to bear arms, you're going to have free speech. All of that stuff came from petitions through time, starting back to the Magna Carta. It all came from petitions going to government.
Yeah.
So everything flows from the right of petition. It is how we express our sovereignty. It is how we express or how we present our instructions to government. It's how we exercise our power. And so, you know, this is the Republican form of government that was guaranteed to us in Article 4, Section 4 of the United States Constitution.
Yes. So on that, so what I was going to mention is that in all of those groups, all well-intentioned, like you said, I felt like there was a level of futility that I couldn't put my finger on until just now when I heard you expressing emphatically, you are going to take the Constitution and you're going to give it to them whether or not they want it or not. You were going to show them, and you were going to fight on the side of the Constitution. It's very interesting because one of the things that they constantly coach in our groups every time we go to the Capitol, and remember, everybody be calm, everybody be cool. And there's this false sense of, if you're really professional, you'll get something done. And I was ardently against that. I was like, no, I feel like this is our Capitol. This is ours. They work for us. And it made me have a reflection. In my very early years, I'm from South Carolina, and I used to work for this extraordinarily arrogant attorney named Joseph P. Serrato. And Joseph P. had everything monogrammed, and he would sit in his office with his feet up on the desk, and he would chain smoke with a filter next to him. And he would address clients like that would come in. And it was always so mind-boggling to me to see an individual coming in to pay him for his services while he spoke to them in a very, very condescending, belittling tone. And it really had that same vibe to me. So I am extraordinarily appreciative of your approach, because I believe the approach should be clean, clear, and direct. And let me just go ahead and clear this for you. This office belongs to me as a citizen, exactly like you were saying. The next thing is, and I wanted to say, Claudia, to this point, do you have anything Governor candidate Gentry has mentioned that we want to ask him to this point, so we don't have to retract too far?
Oh, hi. And first of all, Semper Fi, Marine veteran as well. I do believe that when you're faced with something that you should not just accept what you've been served, that you should question, you should go after, you should want to know. And I always ask for proof. Show me where it says that. I want to see it. And then I'll back off, but I question. And I think a lot of parents do not assert, or other citizens do not assert that right. And they just kind of give up. And like you said, they just kind of go with the flow. And I'm not one of those go with the flow. I want to know, if I can lead, I will. And I want to. So I have followed what you have shared. When Kimmy shared a little bit, I was completely interested. We were actually messaging late one night on a Friday trying to figure things out. And I actually got the book. I wanted to read it. I went to a bookstore and I asked, I'd like to, get the Constitution of the Texas Constitution. And they said, oh, it's in the history section. And I said, shouldn't it be in the law section? Because I'm interested. And it was shocking. It was in the history section when I believe it should have been in the law section. So I started going through it. I was reading up on a lot of what you were doing. I was very interested in the remonstrance myself in Texas. Right now we are in our session is over, but we have a special session coming up. And I was wondering if this is something that we can prepare for a special session. Governor Abbott gets to select what he puts on the agenda. And I'm curious, how can we, prepare this and submit this to his office for him to address during the special session? Or do we have to wait for the session for the legislative session in 2023?
The first order of business, and this is typically in their rules of order, the first order of business is the people's business. Gotcha. Petitions are the first order of business. So whenever they assemble, if they've got any petitions, that's what needs to be heard first. So my last one, I can share this on my screen, but I'll just show it to you on camera. This is all I filed last time. That's it.
Okay.
Very short document. That's it. And I'll read it really quick. It says, a large number of citizens from across the state of Tennessee assert right to apply to the powers of the government for redress of grievance and proper purpose by address, pursuant to the Tennessee Constitution, Article 1, Section 23. The right of citizens to remedy by due course of law and justice administered without delay, Section 17. and the right to instruct representatives, the obligatory clause under Section 23, are rights also hereby asserted, requiring this application to be heard, considered, and decided according to the supreme law of the land and conscience of the members. This application, made by good citizens of the state of Tennessee, seeks resolution for the members to welcome proper petitions and remonstrances and hear and decide them as required by our beloved Tennessee Constitution. This application seeks further resolution to reinstate the Propositions and Grievances Committee. And then I presented them with signatures from citizens from across the state, with their address and their signature on that. So, that was very short. So the next step now is that the speaker is supposed to schedule an address. I said, I don't care, if a member, I wrote up a speech and I said, if a member wants to read the speech, I'm fine with that. I said, I know way more about it than anybody in here. And I think I could address the House much better on this topic of why we need to restore this and resolve to welcome petitions. There's nobody that can present a better argument probably in this country than aside from myself. The speaker is ignoring me right now. And so we have to push them. So my next step, I'm going to file it first week in July. And I'm going to do a petition for writ of mandamus against Speaker Cameron Sexton, the Speaker of the House of the Tennessee House of Representatives. And I'm going to ask the court to order him to perform his duty to assemble the members and to have me address them or have a member address them on my behalf. But we exercise the right to address. So we have to engage them in public opinion and cause outrage, in the public around us and say, are you not upset about this? Because you should be. You should be outraged. This is no different than if they strip us of our right to bear arms, stripping us of our right to address them. And the right of address is far more powerful than the right to bear arms. Case in point, I was a Force Recon Marine for 8 years. I know how to fight. I know how to fight very well. And if I geared up and grabbed an AR-15 and about 10 30-round magazines and put on body armor down there, I probably wouldn't get very far, and I would have accomplished nothing except the media would label me a lunatic. But instead, I went down there lawfully and peacefully with a remonstrance. And I said, I got some problems here, guys. And as a result, they vacated the Board of Judicial Conduct and reconstituted that agency. I had to get filed in the House. With the clerk, I just went to the clerk of the Senate, and I just handed it to the clerk of the Senate. He filed, stamped it, and accepted it. When I went to the House said, you got to get a member to file it. I said, well, where does it say that? She's like, well, that's our policy. I'm like, it hasn't been done in 170 years. You don't have a policy. Show me your policy.
Yep.
And she said, well, that's our policy. And I said, well, let me get you on camera and to make a video of you saying you're not going to accept my remonstrance. And she literally ran in her office and slammed the door. So I went to 98 members of the Tennessee House, and I said, well, will one of you file for me? I got no response except one man. He called me up, and he said, man, Mr. Gentry has some pretty heavy reading there. Is that it was very complicated. I want to reform the judiciary. It's you have to lay it out pretty carefully when want to reform attorneys and judges, right? Well, I asked him if he'd speak with me, and so he invited me down to his office. There's 700 pages of appendix proof and a 72-page remonstrance. It's a stack of paper. And I said, will you file this? And he said, I'm going to go talk to some members across the hall, see if I'm not going to get my head chopped off. And I don't know. I'm not going to tell you yes. I'm not going to tell you no. And then that day he called me up, and it was announced on the floor. Have you guys seen that? Have you seen the announcement of that?
Yes, I did.
You did.
So that's incredibly powerful. A citizen.
Huge. Huge accomplishment. We are extraordinarily excited that you were able to get that far. That's huge.
So the second time, I just did this just recently, beginning of May, I went in a second time. And this time, last time I was like, please, will one of you file this, right? This time I went up to my Representative Johnny Garrett. He's my district representative for the House. I said, I'm not asking. I said, you're going to go file this with the clerk. I was like, here it is, file it. And so he wrote me back an email, not, let's see, like 2 hours later. I met with him for an hour in his office. It was, it's like a hostile witness deposition, asking me, what makes you think you have a right to address the body? And then he recorded it. I mean, it was literally like a hostile witness deposition. But he wrote me back and he said, this is like 2 hours later. And he said, the attached petition, which you left with me, has been filed with the clerk, and it will be announced in today's session. And it was. So that's huge progress. That the first time I had to beg them, I could only get one. This time I just went to my representative. I said, I'm not asking you. I'm instructing you. I'm telling you what you're going to do. You're going to go file. And he did. He performed admirably.
Yes, absolutely. So
we got to take a break here. We'll be right back.
Okay.
Good evening, sir. Where are you coming from?
I was just at a buddy's watching a game.
Have you consumed any alcohol tonight?
I had a couple beers.
Thanks. Can I ask you to step out of the vehicle, please?
How many drinks does it take to impair your ability to drive safely? Having even just a few casual drinks can impair your driving ability to the point that you could lose your license for at least 3 days or more.
Hi, honey. Can you come pick me up?
Play it safe with alcohol. If you plan on drinking, don't plan on driving.
We're back on Speak Up, Real Talk, Speak Up and Empower Hour and the Andy Martens Show. We're going to go 90 minutes, I think, today. Just a quick comment to John, what he was saying. I think traditionally as a Canadian, well, I'm close to the U.S. I'm at the tip of Michigan, but I'm in Ontario. Traditionally, the governments, liberal Democrats, have been weak. Go back to Lyndon Johnson in Texas. It was full of corruption. Barack Obama, Jimmy Carter, Bill Clinton, I think, led his weak policies led to 9/11. And now we have Joe Biden, who was, if I was an American, I would be furious at his world stage performance at the G7. But then again, our Prime Minister, Justin Trudeau, is pretty weak too. So I took my jacket off. I want it to look exactly like Kimi. Go ahead, Kimi.
Again, I just wanted to let everybody know this evening our special guest is gubernatorial candidate for the state of Tennessee, John Gentry. John, would you like to take a minute to address your constituents? If you were running a minute ad there in Tennessee to reach people, what would you be telling them?
Well, if any voter out there that is looking at who to vote for, literally, if you're an American patriot and you believe in Americanism and the American way of life, I'm the only candidate out there that is constitutionally competent. My work is about restoring power to the people. It is not about gathering more power for government. There is so much pretended legislation. Pretended legislation is legislation that sounds good, but it's actually for corrupt purpose. And that's about 90% of the legislation that runs through Tennessee General Assembly. And it is all acquiesced to by the governor. As governor for the state of Tennessee, we don't have veto. like we do with the federal Constitution. But in Tennessee, the governor can state in writing why he will not sign. And that is what I will do with this pretended legislation, is I will state in writing to the General Assembly why I won't sign, and I will put it out to the people and expose why I believe that legislation is corrupt. Won't sign it, and you will not find any candidate who is willing to stand up to corruption in government the way John Gentry has been doing and will continue to do.
Excellent, excellent. Well, thank you very, very much for that. And we're going to make sure we're going to get this really, really circulated. So I wanted to get your opinion. Okay, so in your eyes, what does a reformed judiciary look like? What if you had a wand and could wave it? What would that new judiciary look like if you could reform one segment of it at a time?
I've looked at it very carefully. Like, what do we need to do to restore justice back to our courts? What needs to happen? And I've presented this in remonstrance. I've also testified about this. And there's several things that must happen. First is we need live stream recorded proceedings available on demand to the public. We have to provide transparency in our courtrooms. The Tennessee General Assembly, they have cameras in every hearing, and we can do things to protect juveniles, to protect victims. I want the camera, quite frankly, I want the camera pointed at the judge and only at the judge. He's the only one I care about watching. But if they want to organize the video proceedings, to capture the witnesses and the arguments, we can do things to protect witnesses. But I really just want the cameras pointed at the judges. I want drug tests for judges. We've had cases. There was a horrible case in Knoxville. A young man and young woman were abducted, and they were both sodomized. They cut the breasts off the woman. They wrapped the man in a carpet, burned him. They poured bleach down the woman's throat. I mean, it was horrible, horrible torture. And the judge was on drugs. And they had to retry that case, and the family had to go through that hell a second time. We also had Casey Moreland. He was arrested here in Tennessee by the FBI. While in custody, he testified about going down to Costa Rica and smoking marijuana and buying prostitutes with other judges and attorneys. So, these guys, if they're going to be coming after parents for smoking marijuana, they don't need to be smoking marijuana themselves. Okay. As a financial professional myself, I always have to take a drug test before getting employment. I don't think there's anything wrong with it. And I think these judges should go through drug tests, randomly and at least once or twice a year. Okay. I want every citizen advised of what a right of due process means. And the Supreme Court of the United States has laid it out clear in numerous opinions. We have a right to be heard. We have a right to present argument. We have a right to present evidence orally. We have a right to confront adverse testimony face to face. And there are several aspects to it. I just want people handed a piece of paper that says, you have a right to hear due process, and here's what it means. It's the same argument as Miranda v. Arizona. In Miranda, they said that a person doesn't have due process if they're not advised of their right to remain silent and warned of the consequence. So we should be advised of the right that we have a right to due process. Here's what it means. You have a right to a trial by jury in civil and criminal cases. And the warning is, if you waive a right to a trial by jury, you may be subjected to a biased or corrupt judge, and there ain't much you can do about it if you waive your right to a trial by jury. That's the warning. We have to abolish these judicial oversight agencies made up of judges. In Tennessee, they created the Tennessee Board of Professional Responsibility to oversee attorneys. That agency was created by the Tennessee Supreme Court. And I don't know about the rest of you, but I know how to read. And my Tennessee Constitution, in Article 6, my Tennessee Constitution, it only grants judicial power. Tennessee Supreme Court cannot create any agency. That is making law. And they do not have the power to make law. And then they make attorneys pay like a $300 fee to cover the cost of that board of professional responsibility. That is taxation. That is a judiciary exercising power that was not given to them in the Tennessee Constitution. Both of those agencies, the Board of Professional Responsibility and the Board of Judicial Conduct, they have to be abolished. And we have to restore legislative oversight of the judiciary and the power of impeachment back to the houses. If we do all of those things, even if we do just a couple of those things, we'll make great strides toward restoring justice in our courts. But without the transparency of video, without the accountability of remonstrance, without the advising of rights, people are just going to continue to suffer the tyranny of our corrupt courts in there. But those are most of the things that I think need to happen. There's some other things. We have Tennessee. We have the Tennessee Code Commission. It also has the Chief Justice as a member. The Chief Justice of the Tennessee Supreme Court is holding an expressly prohibited second office of trust. The Chief Justice of the Tennessee Supreme Court is constitutionally incompetent. He's Article 6, Section 7, no judge shall hold any other office of trust or profit. The Tennessee Code Commission is an office of trust with the Chief Justice of the Tennessee Supreme Court holding a seat. And it also, as part of that board or Tennessee Code Commission, that Code Commission has the authority to prepare and present bills. That's legislating. And if he's in there compiling, editing, annotating, and perhaps proposing legislation, he renders himself incapable of office to determine whether a statute is constitutional or not.
That's right. That's exactly right. Just like you said earlier, it's the fox guarding the hen house yet again.
That Code Commission, they structure the code so that it is intentionally deceiving and that it is almost impossible for the layperson to find something in there. So it's, there's so many aspects to this corruption and what's going on in the courts.
Do you think that there is, sometimes I shudder at sounding too conspiratorial, but I have always believed that down to the simplest of things. The best example is my children go to a charter school. And in the aspect of the charter school, I feel like I was, I appreciated what they were trying to do. But I look at a lot of things in the same way. At this particular charter school, you make application. If you don't have a response within 3 days to any questions they ask you online, you're immediately dropped down to the bottom of the line. Then within 4 days, everything is extraordinarily strict all along the way with the application process. And I feel like along the way, my daughter was number 325 on the wait list. So in normal terms, you would think that, okay, so it could be never that she gets in. But the reality is all of those numbers before her didn't complete all of the hoops to jump through in order to accomplish the very simple thing of just getting enrolled in the school. Do you think that a lot of times things are deliberately convoluted to make it difficult for citizens to exercise their rights intentionally?
You're talking about related to court proceedings, right?
Yes, related to court proceedings. Yeah.
Here's what happened. In the 1940s, 1950s, attorneys generally had about as much education as a plumber, and they charged about the same rate as a plumber would charge. About the 1960s, they created, the billing concept in the 1940s and the 1950s was based on what a person could afford, what the attorney did for them, and what the outcome of the case was, which is, much like, you go to any contractor today, a good contractor or something, a company that provides good service and how they bill, that's how attorneys used to bill. Well, in the 1960s, they come up with the time is money concept. And that's where they started billing in increments of an hour. sometimes 15 minutes, sometimes tenths of an hour. Every 6 minutes they bill.
Yeah.
When they created the time is money concept, the time that it took to get things done increased dramatically because now their compensation is based on it. So what happened from there is to make it take longer. They started complicating the process with the rules of procedure. And they kept adding more and more rules and making them more and more complicated. And it was for dual purpose. One, it's to make less what lay people can do for themselves. And two, it's to complicate the process to make everything take longer. Once the legal profession complicated this process as much as they could, then they started introducing new torts. The economic theory of this country used to be caveat emptor, buyer beware. Exercise your judgment before you buy a product or service. They transformed that from caveat emptor to manufacturer liability. And so now you got slip and fall, negligent driver, the McDonald's coffee spill case. So what they're doing is they're creating new torts. Those are new revenue streams. Just like a manufacturer introducing a new product line, all those new torts are new product lines for the legal profession. So as they've maxed out the complication of the process through procedural law, as they've created as much torts as they could, then they started creating new torts statutorily. And so they started doing things like they have the 5-hour meal break rule in California. I can tell you the citizens of California were not saying, I need a meal break in 5 hours. That was Joe Attorney down with Billy Bob legislator saying we need a new revenue stream. And this one's going to be great. You're going to love it. Yeah. So now you got them. And these guys, another part of this is the whole law school system and how expensive it is for law school. So these guys are coming out with $250,000 student loans like a house payment.
Yeah.
So they've got to pay for that. So they're hungry. They got to make money. And the next process, so procedural law, complicated, introduce new torts, legislate new torts. The next step is you've got to start violating rights and engage in vexatious litigation. When you engage in vexatious litigation, now you have to start making rulings based on false and unsupported allegations. You have to start excluding evidence wrongfully, all the other little tricky things that they do to deny due process, and especially for pro se litigants, where the judges start interrupting them and start, well, you didn't do it by this rule or that rule, and you're not going to be heard today. You didn't get a notice of hearing. All the little tricks that they use to deny due process. You can't get through the vexatious litigation unless you have no accountability.
Yeah.
And oversight. And so that's where we are. But now people have gotten so they don't trust the legal system, and so they're avoiding the legal system now. Arbitration agreements and all of that stuff. So now, there's more legislation to get people in there criminally, and when they get somebody on the hook now, man, they're going to latch onto you and keep you in that court proceedings for years, as long as they possibly can.
Absolutely. We see everything that you just itemized step by step by step. And that brings me back. Your speech said, this is not a Tennessee problem. This is a problem across the entire United States. So I completely agree with that. Claudia, at this point, anything that you'd like to ask?
Well, like you said, for pro se litigants, that's what I am now, and what Kimmy's been doing. I actually help veterans that have been going through this, whose disability and their service has been used against them in family court to find them unfit and absent parents, and that's what they've used against them. So I'm trying to legislate for a change where do we follow under the Americans with Disabilities Act? Do we have these special accommodations that we could be filing for when we file pro se litigant rights, or we ask for accommodations? Again, for the recording of these hearings, because oftentimes we have to pay for transcripts, and that's something that we can't afford. So I'm trying to make legislative change for that and bringing more awareness to the legislators. I just had a meeting last week with a U.S. Senator here in Texas, and they just kind of kept deflecting these issues. And I had a couple of veterans on the call with me to address these concerns.
Let me share some of the stuff that I do myself as a pro se litigant, and what I help people with is number one, very often they exclude evidence.
Mm-hmm.
So I don't present myself pro se. I present myself sui juris. Sui juris means that I'm quite capable of and I'm of sound mind, and I'm capable of representing myself. It's a much stronger position, in my opinion, to have standing in the court. When I file something, I prove my case. If you watch an attorney's motion for something, it just makes some general allegations or just makes some general statements about what's going on. I actually prove my case in my motion. So I'll say, this person did this, and as evidence of that, see Exhibit A. And another thing I will do is, along with that motion, is I will attach a memorandum of law on why the court should grant that motion. Because pro se litigants, they will not let you talk, and they will not let you present evidence. So you attach your exhibits to your motion, you attach your exhibits to a memorandum of law, and you prove your case in a memorandum of law. You get all your supporting authority in there. And whether, if they rule against you, then this is another thing as a pro se litigant, I do not take no for an answer. In Tennessee, Rule 5402, it's titled, this rule is titled deceptively. It's Rule 5402, and it says all claims settled, multiple parties. I think, or it may just be multiple parties is the title of the rule. But what that rule actually says is, until all claims are settled, no matters are terminated. So until there is a final ruling in the case, whatever rulings they had before, you can do a motion to reconsider. And I've had judges come back and they say, "Oh no, I already ruled on that." I said, "I don't care if you ruled on that. Until all claims are settled, no matters are terminated. Are you denying me process here?" So I go back in and I do a Rule 54 motion, and I say, the judge is wrong. That he's violating procedure. He's making a ruling based on false and unsupported allegations. So that's a very important tool that I use. If they do have a final ruling, always do a Rule 59 motion to alter. If you can prove fraud in the case, you come back and do a Rule 60. So, like in my last mandamus case, it was rife with corruption from the Deputy Attorney General. That was opposing counsel, Deputy Attorney General, falsifying evidence in my case, literally falsifying evidence. So, I went in and I did, they dismissed my case wrongfully. It was an involuntary dismissal, even without a hearing. And so I did a motion to alter, and then I came back and did a Rule 60 all before I did my notice of appeal in that case. So I get as much evidence and everything that I can into the trial court. Because if you don't have the evidence in the trial court, then you can't go against the weight of the evidence argument in the appellate court. You can't have evidence in the Court of Appeals. So get all your evidence in as attachments, exhibits, appendixes. Get all of your evidence in that way. You can submit flash drives and attach them to a motion if you've got video, whatever. Don't wait to present it in the courtroom, because they've always got a way to exclude it, object to it, whatever.
I love it. That is phenomenal advice. I can tell we probably have a dozen people that just a tiny bit of advice will change things for. And while we're on it, I would love to get your opinion on judicial discretion as it's carried out by a district attorney, and your thoughts on the grand jury process.
In Tennessee, we can petition the chair of a grand jury. Statutorily, any citizen can make an accusation of a crime and go to the chair of a grand jury. But it's up to the chair whether he wants to convene the grand jury. and most of them are corrupt as well. But you can, but you can go to them. I would record it. If I went in there, I would bring a video camera and say, "I'm going to record this. Do you mind?" With the whole grand jury process, it's absolutely something we've got to fight to get back. That citizens can bring grand juries, but I think it's largely a corrupted process that the judiciary is controlling. There was another part of your question. What was it?
Yeah. Okay. So you just answered it. You wanted to bring back, what was the process within the DA's office that you mentioned just now?
Oh, well, that was the other part of your question. Absolutely. Police officers and DAs, they have prosecutorial discretion. It's a sound doctrine. Also rooted in corruption. It just gives them to prosecute, whoever that they like, or whoever is connected, or state officials that they don't want to prosecute. That's what prosecutorial discretion is always used for. And I don't know how to fight that. But what I do know is if your rights are violated by government, that you have the right to remonstrate. So skip the DA. They're corrupt. Skip the grand jury. Go to the legislative houses and address them. It is far more powerful than going through the judicial process and the judicial branch, because they're all corrupt. At least in the legislative branch, they're much more held accountable by vote. And most of the legislative houses have video recording in the legislative houses. And the publicity of that, the Supreme Court of the United States, Pacific Telephone and Telegraph, the crucial prophylactic aspect of justice cannot occur in any dark corner or covert manner.
That's right. I totally agree. That is absolutely an amazing point. And Claudia and I work with several groups, and in each one of these groups, we have the same issue she mentioned earlier is having the funding to be able to pay for these extensive court records. Only one state, and Claudia, correct me if I'm wrong, that we know of does what you're suggesting. The live video stream that everybody has an access to the record on is in North Carolina. In North Carolina, doesn't matter how many days your trial was, doesn't matter how long it was, you can go down there and you pay $5 and you get a copy of all of the video. Comes to you right on the hard drive. The only thing that you're paying for is the little dump drive. And the only place that we know that exists is North Carolina.
Yeah, but you still typically have to get that transcribed, and that has to be done by a court reporter. I myself, I will never, ever walk in a courtroom without a court reporter, ever. One of the most dangerous things a person can do is seek justice. I will not go in a courtroom without a court reporter under any circumstance. And what I pay typically like $200-300 per diem, and then $5 a page is what I pay here in Tennessee. There's another agency like Houston for pro se's. You got to put down $1,000 deposit. It's and they do that intentionally against pro se's.
Of course, absolutely.
If it's an attorney, they're going to bill them, and the bill's going to be $400-600. But if you're pro se, Houston wants $1,000 up front. Mm-hmm. It's absolutely ridiculous.
Well, the reality is this could all be easily transcribed with an audio recording app. We have progressed. We do not need somebody sitting there with a transcription machine anymore. If we have an audio recording, that audio recording can be transcribed instantly with the appropriate software. And if they want to charge somebody $5 because they've already had it transcribed through a very expensive system run by the court, that's fine. But what we have, what we have here in San Antonio is we have independently contracted transcribers who don't even have an affiliation to our local county. So my local transcriber sends me an email from her Gmail account at home. And she sits there and she transcribes. She herself doesn't work for the county, and she uses her job with the county to do independently contracted work with people like myself.
Yeah, that's what most of the court reporters, or all of the court reporters here, are not government employees. They're contractors.
Okay. Ours are both. Ours are both. And I thought that is another big conflict.
Another strategy that I use is I use a lot of the same tactics that attorneys use. I go in with, if it's child custody case, I go in with a motion to dismiss. Failure to state a claim. Where's your evidence? And I also go in on the attack. This is one I've used several times. This particular one there was a GAL that was assigned by the court, and I went on the attack on this GAL, and that GAL withdrew the very next day. Went into court and withdrew with that. And so, like, this was a domestic violence, false accusation. It says the order. And I got this actually from a friend in Arizona who wrote this. But he said the order of protection has been struck down by the judge as being preposterous on its face. Father asserts that sworn accusations at the behest of her attorney amount to perjury, as stated on the sworn document fabricated by this attorney in his attempt to contrive a custody battle in his artifice to defraud mother out of untold thousands of dollars. Since the parties are now married, the attorney is directly defrauding both parents. Father declines to file criminal complaints against mother, as father believes this would not be in the best interest of children. Alternatively, father believes that filing bar complaints, state and federal criminal and civil complaints against the attorney is in the best interest of all the children of the state. Perjury is a class 4 felony. The conspiracy of this attorney to defraud renders him vulnerable to prosecution for both fraud and subordination of perjury. His sentencing guidelines thus up to 3 3/3 years in the state. And I throw in there,
spectacular. Can I just tell you that is amazing.
I'll put it in there, and I'll write it in there. This person is a predator. I write it right in. I'll just say this attorney is a predator.
That is spectacular. Okay, so do you practice family law?
Do I practice family law?
Yeah.
No, I'm not an attorney.
Okay. So everything that you've done thus far has been self-taught.
Yes. Well, I've been fighting some of the best attorneys in the country for several years, and basically I've apprenticed under some of the best attorneys in the country. These guys that I'm going against, the first 4 attorneys that I went through in federal court, they're with a law firm that has 980 member partners across 6 states. It's an incredibly powerful law firm. Mm-hmm. And the attorneys that I was suing, one of them was a partner in the law firm who is now disbarred. Not disbarred, but she's been suspended now for about 3 years. And I'm pretty sure that's just a result of judges protecting that attorney from my lawsuit and my exposing the corruption of those judges all the way from Middle District, Tennessee, through the 6th Circuit, through the Supreme Court of the United States. Every judge hates that attorney because none of this, I would not be here if it were not for that attorney. Yeah. And so with the attorneys that were representing her, they taught me every trick I know.
I love it. I love it. That is amazing. Okay, so because I know a lot of our viewers are from the parent rights groups, I wanted to ask you, what is your opinion of Title 4D?
Title 4D is unfortunately used to drain and deplete our Social Security funds to support human trafficking that's occurring in the states. It's a major revenue stream. I am absolutely against it. It's also at the heart of my fight. And how I fight that is by restoring due process. So children and seniors cannot be taken into state custody wrongfully if there's fair due process. So that's one of the reasons that I'm fighting to restore due process with this. In Tennessee, we had a case just recently in Knoxville where 2 foster parents buried a child in the backyard had been, starving them, locking them in a basement, moved out of that house, went to a second home, and then buried a second child there. The fact that that happened, the state cannot guarantee the safety of children. And they should not, but the state is absolutely very much incentivized through Title IV D&E funds, federal incentive money coming from our Social Security funds. So it's a double-edged sword. It's depleting the retirement of Americans while also wrongfully taking children and destroying the lives of mothers and fathers who go through this complete, legal abuse in child protective service cases and when they take adults. It's really bad, the stuff that these attorneys do to these families. It's horrible. It breaks my heart. It's hard to listen to these stories from me.
Yes. I see that you've had a front row seat at some of the most horrific stories. I'm familiar with both of the stories that you've mentioned. To my other hosts this evening, is there any questions that you all have for Mr. Gentry at this point?
I have one. When you filed your remonstrance, how many petitioners did you have, or was there a requirement of petitioners?
So the first remonstrance I filed in April of 2019, I filed it, I had no signatures, but I filed it on behalf of similarly aggrieved citizens. I stated in my jurisdictional statement that this is a public petition and a formal written protest in that. The second one that I filed, I went out and picked up signatures from across the state. This one, it was literally from across the state, north, south, east to west. I only had like 355 signatures on the second one that I filed.
Okay. And was there a special requirement with regards to those signatures, or were you able to acquire them online?
I did both. I have a form. I don't know if I have a copy of it handy. I don't think so, but I have a form and it says, I so-and-so stand with Mr. Gentry to restore the right of petition. And then they have a signature line and put their address on there. And then I created the same thing electronically where people could go to a site and sign electronically. And then I cited the Tennessee statute that says, by my, signing here, that this electronic signature is considered legally binding or a legal signature.
Excellent. Andy, anything from my Canadian compadre,
Well,
Mr. Gentry?
Sure, Kimmy. I'm just astonished as a Canadian. Tennessee is a red state. Texas is a red state. I thought that red states have less corruption than blue states. Washington, D.C., all these blue states have more corruption, but it seems like it's across the board right now.
It's just different kinds of corruption, But no, it is absolutely. With the red states, the corruption is to benefit certain special interests, primarily business, health insurance, insurance industry, and very much the legal industry, the legal profession. With the Democrats, they sugarcoat a little bit different. And they say, this is to support this cause, but the money always gets funneled away. They never care about, really supporting and helping people. Like for example, the family, Family Safe Act from the Clintons. That's where the Title IV incentive, came from. Right. And let's help the states, provide foster care for children. And what a beast it has turned out into. Tennessee is about 100,000 kids are investigated. Only 11% of them are for abuse. The other 89% are neglect or other reasons. Dirty house, don't want to vaccinate, don't want to have a certain medical procedure. Mom, pop, positive for marijuana, whatever.
Yeah,
look at all the corruption the Clintons got into before Bill Clinton was elected president. Whitewater and all of this. It's astounding.
Well, the reason that this is all happening is because the right to petition is so oppressed, it has been wiped from our knowledge. That's why this is happening. The right of petition, peacefully exercised, it took the place of prolonged discontent and the presentation of a long list of grievances at the point of a sword. And I got that. That's out of actually, this is a constitutional history. Ooh, see if I can get this in. It's a constitutional history of medieval England.
Okay.
Wow.
And literally, it's out of this book that the right of petition, it took the place, or petitions peacefully presented, it took the place of prolonged discontent and a cohere. They say a cohere of grievances. A cohere is a notebook. In other words, a laundry list, a big list of grievances at the point of a sword. Petitions were intended. The right of petition was intended to take the place of uprising. Pitchforks and torches, it was put in place to take the place of that. And in the 1640s, Parliament, House of Commons, affirmed that commoners have the right to prepare and present petitions.
Yeah.
And it's fundamental, to our form of government, and we've all got to work and start defending this right. When in the colonial period, colonial governors were removed from office for oppressing this right. And it wasn't just the misconduct, it was like the oppression of this right was cause for taking up arms. And it's actually the number one reason that we declared independence from Great Britain is because Great Britain ignored our grievances. And you can read in the Declaration of Independence, for subjecting them to mock trials for the murders on the inhabitants of these states. They were talking about the British ministry, British judges being above the law, that the king would do nothing about it, that he would allow this. And now we've got the same thing. Our government will not do anything against corrupt judges. And I just posted about this today. Mother in Connecticut killed herself and killed her daughter and was involved in a custody battle. Those cases, it is my strong opinion that it's the attorneys weaponizing spouses, and it gets so bad, that they engage in murder suicide. The blood is on the hands of the courts for that stuff. That loss of life is the direct result, I can assure you, of attorneys and judges. Maybe there's a little bit of instability, some personality disorder or something, but it wouldn't come out the way it would except for the corrupt proceedings. And we have nobody to complain to right now, except that I believe, I know in my heart that we are going to get the right of remonstrance restored, and there is going to be a healing across this republic as has not occurred since we declared independence from Great Britain. It is going to be a new renaissance.
I love it.
It's going to be incredible when this right is restored, and it's already, we've taken the first steps here. Gentleman in New Hampshire is fighting for it. We've got Florida fighting for it. Now we got Texas, and Texas with a strong constitution to do it by address. We're going to get this done.
I agree. We are your steady soldiers, Mr. Gentry. As I mentioned earlier, we are here to fight alongside of you, and super very excited to have met you, come across you. I wanted to just tell you that we are going to do everything that we can to mimic your behavior in Tennessee in our legislature. Everything that you mentioned tonight is absolutely 100%. Not that you needed any verification that this was happening across the nation, but it sometimes it helps parents like us to be able to say things to other parents like, you know what, maybe this wouldn't have happened if it wasn't for more inflammation being thrown on an already difficult situation. And that ability to be able to hold people accountable for basically instigating a more difficult situation. Our children are being destroyed. And last night, we had another opportunity with Claudia, and I have a 19-year-old daughter. And I'm not doing anything traditional with her that I did with my older daughter. So, you know, that my older daughter goes to college, does 4 years, comes home, finds herself, goes for another 2 years in Santa Fe with all of her people. And she has a very you know, just everything that makes us crazy about today's society and student debt and ridiculous degrees that are unusable. This child came along with us to assert a penal code that we have in child protection. And my 19-year-old daughter was there with a tenured police officer explaining a penal code to him. And after she explained it to him, she asked him, she goes, "Why is it that I'm 19 and I'm explaining these penal codes to you?" And exactly like you've said, on probably a half a dozen occasions, they turn a blind eye, they ignore, they dismiss, they minimize, they try to do everything that they can to shove things under the carpet to make it out like they don't exist so they don't have to be held accountable. And everything that we've spoke about tonight is that same thing over and over and over. And for my 19-year-old to be given that knowledge at 19, I would have done anything to know what I know now at 19. The only part about it that is somewhat disheartening is wondering where as a whole we went so wrong that my daughter says to me, she said, "Mom, I have always had a false sense of security that the government was there to protect me." And watching a police officer allow an underage minor walk away without their protection and disregard the penal code was a really big deal. But I stand behind it because as we're sitting here tonight talking about the truth that needs to be discussed, it's an inconvenient and uncomfortable one. But if we want more warriors like you to go out there after it, that spirit is going to have to be passed on to 19-year-olds and 20-year-olds who are seeing it firsthand. And I am honored to be a part of that, and honored that I was able to find your information, and very, very honored to have you here tonight, because the one thing that we're running a little bit short of here in San Antonio and all of our groups across Texas right now is hope of something different. We have an extraordinary amount of parents who are feeling like, are you all just giving false hope? And the reality is it's going to take new information given to us, like the information that you've given us tonight. That motion to dismiss is poetic, and I can't wait to pass that information on. It's spectacular. You know, the orders that you've quoted, those are extraordinarily quantitative for us. And I thank you. Anything else for our guests tonight, Andy?
Well, I have one final question for John. It's been great. If more governors in the United States were like John, as like Governor of Florida, Ron DeSantis, would this be a better republic? Because he seems to have his act together in Florida, where the other governors in the other states do not.
Here's the root of the problem with our leadership is they have no understanding of the founding principles or even of our Constitution. Now, in the Tennessee Constitution, there's a miscellaneous provisions, Article 11, Section 8, and most people don't go look at this. But in Article 11, Section 8, it says the legislature shall have no power to suspend any general law for the benefit of any particular individual, nor to pass any law for the benefit of individuals inconsistent with the general laws of the land. nor to pass any law granting any individual or individuals rights, privileges, immunity, or exceptions other than such as may be by the same law extended to any member of the community who may be able to bring himself within the provisions of such law. That eliminates all special interest legislation right there.
Right.
And so if, these constitutions, they establish our form of government. And as you know, in United States v. Cruikshank, whether a government is Republican in form or character, fundamental to that is the right of petition.
Right.
So right of petition is part of our form of government. Judges not holding second offices, that's part of our form of government. You know, the English Whigs were complaining constantly about plural office holding. And so when we created our Constitution, we said one person, one office. Those provisions are being violated today. So there's aspects of in our state and federal Constitution that it creates our form of government in there, and conduct of the legislative houses, the executive branch, the judicial branch. They're all laid out in the Constitution. The framers did that having suffered tyranny and oppression. They did the best that they could. Let me see if I can find this real quick. I've got it on my computer, but I gotta read you this quote because it's out of the law review. I sent you 2 law review articles. Didn't I send those to you guys?
Sure, you did.
It's in. This was on the House debate for the whether to include. Where is it? Why can't I find it? Oh, well, I'm going to go off the top of my head. I wanted to read it to you exactly. But he said, you know, by looking at the Constitution, you know, we can see that the construction of it was to prevent maladministration. You know, in other words, corruption.
Correct.
And it says, you know, do gentlemen here arrogate to themselves better conduct than humankind has been able to show thus far? You know, so do you pretend that you're any better than the corrupt people that we just separated from? Of course you don't. And so what these constitutions do is they establish the form of government, and they provide for certain checks and balances to prevent tyranny and oppression. So if our leadership understood the founding principles, if they knew the specific language of our state constitutions, a lot of this corruption would not be happening. The legislation would not be getting signed because much of it being in violation of a constitutional provision like Article 11, Section 8, judges holding prohibited offices that propagate. Now you've got a corrupt judiciary, and so they can provide no check on the constitutionality of legislative power. And then you've got the judicial branch exercising power they don't have, creating agencies, literally creating agencies, making law, creating attorney oversight agencies. It's all unlawful. And it was agreed in our Declaration of Independence for altering fundamentally our forms of government.
But, you know, I wonder how different things would be if we required a state constitution class and a passing grade of 80 plus before each of our children graduated high school.
So, you know, this problem, literally, all dissatisfaction, it gets fixed if we adhere to the Constitution, because the framers, they were much better educated than the representatives and senators we have today. They had far more knowledge, philosophical, as well as legal, as well as Christian principles that this republic was founded on. They were far better men than those serving in office today, integrity-wise as well as just knowledge. They were far better, and so they did a fantastic job establishing a form of government that would prevent tyranny and oppression. And it is what made this country once great.
Yes. Yes.
And
Yes.
if we want to get back to that greatness and back to what made this country great, we're going to have to re-embrace that Americanism, those founding principles, understanding, what the right to instruct, the right of petition, understanding what's in the Constitution and why they wrote it. It's not, some of the language is old in some of the constitutions, but if you just do a little research and look at the debates, you can start to understand, what they wrote. And we don't need to rely on these lying attorneys in black robes to tell us what the law means. We can read it for ourselves.
Absolutely. Absolutely.
Great show, Kimmy. Great
Yeah.
show. It's like a great TV show. I was glued to the screen here. I didn't go and get my chips or my pop or my beer. But I have two quick comments on corruption. As a Canadian, I look at the American election in 2020. My opinion, is not up for debate. There was corruption in that election that last year in 2020, whether you like to hear it or not. And secondly, you look at the Biden administration, you're not supposed to have your family members working for the administration. Well, they just throw their hands in the air or give you the finger. Who cares? 6 members of the Biden administration have their family members working with the administration. So that's corruption. You're seeing it from all directions in the United States.
This is the United States Congress.
Right.
House rule for the United States Congress. Rule 12, Section 3. If a member, delegate, or resident commissioner has a petition, memorial, or private bill to present, the member, delegate, or resident commissioner shall sign it and deliver it to the clerk, and may specify the reference or disposition to be made thereof. So we have a right to petition the United States Congress just as much as we do our state general assemblies. Now, talking about the 2020 election, so President Trump called on all of his supporters to come to Washington, D.C. to protest the election. What if President Trump had instead drafted a memorial and remonstrance and attached exhibits to it with affidavits of the fraud in those battleground states? And he asked the 80 million people who voted for him to sign it electronically. And he gave that to a member of the House who has a duty to file it with the clerk of the House. And so then they go to committee hearings, and where those corrupt judges across the battleground states dismissed Trump's complaints against fraud election, they would be heard in the hearing rooms of our United States House of Representatives. And it would have settled the question, was there fraud or was there not? Was it sufficient? Well, we know there was fraud. Was it sufficient to change the election? And the redress sought would be recounts or audits like is happening. Right. That would be the redress, is I want to recount and I want to audit of the records. The Capitol would not have been breached. We would have remained a peaceful nation. We would not have the Capitol building barricaded right now. We would have settled this peacefully and lawfully.
Oh, Mr. Gentry, that is spectacular. That is
exactly. We're finding that FBI operatives organized that January 6th thing. They were behind it as well.
And there is no statute of limitations on a remonstrance. President Trump could still do that if somebody would get word to him, but I'm pretty sure attorneys are keeping no attorney. And here's why the right of remonstrance is oppressed. 2 reasons why it's oppressed. Number one is it is the remedy for corruption and maladministration of government. So they don't want it exposed. Number 2 is the judicial branch wants to be the only source of justice. And the only way you're going to get justice in the judicial branch is, 1, if you can afford it, and 2, if it is not in conflict of interest with their own pecuniary interests. If it doesn't affect them adversely, or they're getting enough money out of it. So the judiciary wants the cornerstone on justice. Our courts of law and courts of equity. Our legislative houses are courts of justice. And our courts of justice have been kept from us for far too long. And we have to go back and restore our courts of justice, restore this right of petition, and it's going to change everything. It's not just going to change everything in one state. It's going to change everything in this country. And then it's going to change Canada. And then it's going to change the UK and Australia, because people there are watching the work that I'm doing as well.
That's right. We're great job. Well, we're going to have you on again. And Kimmy, that's a wrap. Thank you so much.
Yes, thank you very, very much, Mr. Gentry, for being here. We are extraordinarily grateful, as mentioned, and we are here in Texas. But if there's anything that you could utilize our team for, we are at your service because we believe in what you're doing.
Yeah,
Well,
and Kimmy produces it, and there's two people that can do a show at any time. I'm one of them, and Kimmy is the other, so we can get a show on at any time of the day.
I'm grateful for the opportunity to help spread knowledge of this work. It's so important to everything and it's happening at such an important time. So thank you guys for helping spread the word.
Absolutely.
I have a quick question. I'm sorry. Where does one get a template on a remonstrance? How do we learn how to put one together?
My website. Can I share?
Absolutely. Please do.
Sure. Let me. You could share it on your screen, and I can put it up here.
It's not letting me share.
Go ahead with it, and we'll attach it to this
But if you go to my website, wethepeople50.com.
Mm-hmm.
So we the people, one word, V as in Victor, 5, 0.com. And there is a resource document page. On that resource document page is a file stamp remonstrance. That one has a excellent jurisdictional statement. And I, at the time, I did not know that I had a right to address government, so I demanded oral argument. I formatted it very similar to a brief you would do with the Supreme Court of the United States. But the jurisdictional statement in there it works with with every state, I'm pretty sure.
Excellent. Well, thank you.
Yes,
thank you very much. Yes.
Okay, great. We'll see you next week. Take care.